The court case is going to play out depending on different scenarios. If you successfully serve the tenant, and the tenant either does not appear or has not filed an appearance, if both of those things are true, if they do neither, the judge will enter an order. Let me back up a little bit. No, this is right. The judge will enter an order setting a date by which possession must be turned over to you, and a date by which any past due amounts have to be paid. Possession is usually turned over a couple days to a week after the court date. The judge will probably give about 30 days for the tenant to pay the past due amounts. If the tenant fails to pay that amount, then you have to open up a collection proceeding against them. And we can, if you guys want, assuming we make it through, I'm supposed to wrap this up pretty soon here, but we can talk about collection proceedings if people have questions about that. But that's a whole separate case, and it's a pain in the butt. So that's if everything goes smoothly and the tenant doesn't defend the case, you get your judgment order. If the sheriff hasn't successfully served the defendant, which often happens, you're going to have to request leave of court to file something called an alias summons. That's basically legal speak for your second try at the summons. And you're also going to want to request leave to serve by a special process server. You're not allowed to serve by a special process server until you've tried the sheriff first. Otherwise, we would always just start with the special process server because that's how people actually get served. A second court date is then going to be set by the court to determine the status of service. So you'll walk out of that court date with leave to file a new summons, which you can do at the clerk's office. It'll be just like the regular summons, except you'll write the word alias on it, and it will cost you $6. And once you file that alias summons, you will want to hire a special process server, and they cost $60 and $80. Often they will only charge you if they're actually successful in service. So you can shop around and find one that only charges if it's successful.
Excuse me, and if this sheriff didn't serve the paper, but I already paid them $60, are they supposed to give me back this money?
That depends on, you want to work that out with them ahead of time. Every special process server is different. When I started practicing, it was a lot more competitive, and you could really easily find special process servers that would only charge if they were successful. Nowadays, I think we pay regardless of whether they serve, but they make a lot more attempts than the sheriff does. And if they're unable to serve, they offer basically to go on a stakeout, and it costs a little bit more, but they'll eventually get the job done most of the time. But you want to shop around, and if you can find one that will charge only if successful. So I assume they're still around. I haven't looked as hard as I should have to find one, but the one that we used to use is no longer in business. That used to only charge.
First, I still need to give sheriff. So
You don't have to give it to the sheriff anymore at this stage. Now you're dealing with.
No, but before, what you're saying before, I can give another server until I try to sheriff.
Right. You have to try the sheriff first. The judge is going to want to see that the sheriff attempted and failed service before it'll allow you to use a special process server. I disagree with that policy.
How much are you paying the sheriff again?
$60 plus a couple cents a mile.
Well, what if he doesn't do that?
That's
I think that's what she's getting at. Is if he doesn't complete the service,
Who will
you're
give
already
you
up
money
to
back?
$60.
You're not going to get your money back. This is municipal government we're talking about.
That's the point. So they make me to pay them to not doing their job, but then I need to pay another person to do the job, and then I need to pay them again.
But that's the point that you're making from the beginning, that if you have an airtight lease and you show that to your tenant, it's like, look, I'm willing to pay this money and it's going to turn out bad for you. The other person's going to be okay, let's not do it that way. The way to insulate yourself from all this stuff is dotting your I's and crossing.
The best way to, anytime litigation is involved, that's a great point. Anytime there's litigation, whether it's eviction or anything else, the best solution is a settlement. You know, it's the best solution is to get your tenant to move out gracefully. So if the special process server is unsuccessful in service, you can then serve by posting. The judge is going to want proof that service was attempted on several days at different times of day, about 8 to 10 attempts. Any good special process server will do this the first time around. You're going to have to provide the affidavit of the special process server to the judge. And if the judge grants you leave the certified posting, you prepare Form 3509 on the DuPage website. It's the notice by posting, file it with the clerk, and bring a copy to the sheriff. The sheriff then is going to have to do the posting and prepare an affidavit that they posted it on such and such a day. And you're going to pay them again to do that posting. So now you pay the sheriff, the special process server, and the sheriff again. So, sorry. If the defendant appears in court and denies the allegations of the complaint, or has filed an appearance but doesn't appear in court, so if you serve them either successfully or unsuccessfully, but they find out about the suit and file an appearance, or appear in court and deny the complaint, the court's going to set a trial date. And at every stage, I recommend having a lawyer, self-serving, but it might save you a lot of headaches in the long run. But if you go to the trial date, I really recommend having a lawyer. But if you choose to do it without a lawyer, you should bring all the documents that you brought to the original court appearance, the ones we listed, and be prepared to prove that your reasons for termination of the lease are valid, and that all the documents are properly served, and refute any of the defenses that the defendant plans to raise. And you'll find out what those defenses are if they appear at the original court date. They'll have to tell the judge what the defenses are. If they've just filed a written appearance, they're supposed to file an answer, but judges in eviction court like to move this quickly, so you might not find out what the defenses are until the day of, and it's kind of a candy court situation. Once you've obtained a judgment, you want to get a copy of the order from the judge's clerk, take the order to the clerk of the circuit court. You've been there before now a couple times. Have it certified, and you're going to pay a fee for this. Take the certified order to the sheriff and schedule an eviction move out, and you're going to pay the sheriff's fee for posting a final eviction notice. Yes?
What's the cost if I just have your office do it? What's the...
We charge, overall, if we can do it on the first court date, it costs $700 for us.
Including everything, you won't tap on fees, $700.
Right, $700.
I don't have to go.
Right. Yeah. And then we charge for each additional court appearance that's required, $400 per court appearance.
And usually there are how many?
Usually there's one. Usually the tenant doesn't show up because if they're not paying their rent, there's usually not a good excuse. So we usually get it done on the first court appearance. And to clarify, when you say tack on fees, you are responsible for your own. If you hire any attorney, you're going to be responsible for your own costs for the sheriff's fees, stuff like that. If an attorney says that you're not, then that just means that they're built into the fee. So yeah, I mean, it's usually pretty affordable to hire an attorney to do this because it's a simple case. So now we're talking about after you've got the order, you're trying to make sure that they actually get out on the eviction date. You will set up a date with the sheriff's office to have them evicted, pay them a fee, and make sure that you get a photocopy of the eviction order so the sheriff will keep the original certified copy. And at this stage, you're going to have some other responsibilities. And you're going to want to talk to each county sheriff to determine what your responsibilities are, but you're going to be required to inform the sheriff if the move-out occurs voluntarily before the move-out date, because otherwise you're going to be charged for their time when they show up. They bill hourly. You'll likely be required to supply movers on the eviction day. So you and two of your friends, if you want, can go and move everything out to the curb. I recommend informing the tenant of what the eviction process is going to be, that you're going to show up and put all of their belongings into a bed sheet and throw it on the curb, and you're not going to be particularly gentle about it, and hopefully they move out without having to bring the sheriff there. Check the night before to see if they've gone, and if they have, then call the sheriff and cancel the eviction. And this is, on eviction day, the deputy sheriff will stand by to make sure that there's no violence while you remove it from the tenant's property, and he's just going to stand there. He's not going to help you move. He's going to be in charge of the sheriff's time. You're required to leave the tenant's belongings on the curb for 24 hours. After waiting 24 hours, you're responsible for cleaning up the mess and throwing it away or selling it.
I was going to ask if it's maybe like a condo complex or some sort, and maybe it's off of a busy road, and imagine that with the association, they wouldn't allow something.
I would talk to the association and find out what the normal process is
Sure.
for that. This is all kind of within the bounds of reason with your location. You don't want to make an ugly situation within a nice complex. And you don't want to cause a scene. It's just got to be somewhere that they can get it for 24 hours and find it. After the tenant's property has been removed, change the locks and lock the windows. And that's the end. So, do you guys have any questions? All right, well, thanks so much for having me.